Parents usually have an equal right to travel, but the moment a child crosses a national border, the legal reality of custody shifts completely. Compare a judge's power at home versus abroad. Domestically, custody orders are hard rules. Judges use contempt charges and police enforce returns. But cross a border and U.S. law has zero automatic authority. You suddenly rely entirely on foreign treaties and local extradition. Assuming a U.S. court order automatically protects your child in another country is a dangerous illusion. The threat is real. Hundreds of children are victims of international parental kidnapping each year. Often, this is a wrongful retention. A legally approved vacation ends, but the child never returns. Co-parents face a tough balancing act. You want your child to experience the world and connect with extended family abroad, but you have to protect them from abduction. The goal is calibrating the level of legal friction to the actual threat level you face. This chart is a risk assessment matrix. It plots the legal status of the destination country on the bottom against the specific flight risk of your co-parent on the side. By categorizing this risk before booking flights, you can put the exact necessary barriers in place so you never have to fight a reactive legal battle in a foreign court. The lowest tier is for amicable co-parents. You trust each other, but you want clear boundaries and predictable travel. Your parenting plan should mandate the basics. That means detailed itineraries, strict rules on who holds the passport, and who pays for travel documents. You need a clause requiring explicit written consent for all out-of-country visits, including exact dates, destinations, and contact numbers. You also need an emergency procedures clause that demands active international health and medical evacuation insurance. These agreements keep everyone informed, but the trade-off is that they rely entirely on good faith. A parenting plan cannot physically stop a plane if the other parent decides to break the rules. The risk jumps to moderate when travel involves countries with very different legal systems, or if your co-parent has strong familial ties abroad. Here, you have to look at the Hague Convention. This is an international treaty designed to secure the prompt return of wrongfully retained children to their country of habitual residence. This chart maps out an abduction. If a country isn't in the treaty, you rely on comity. They might voluntarily respect U.S. laws, but there's no guarantee. Even in a Hague country, you'll still face foreign legal counsel, massive delays, and exorbitant fees. Many nations, particularly those operating under civil or religious legal systems, may simply ignore your U.S. custody order entirely. Foreign courts judge cases based on their own local laws. They might decide custody based on gender, nationality, or religion, rather than the U.S. standard of the child's best interest. Treating an international treaty as a guaranteed safety net is a huge gamble. It is a slow, expensive, and heavily reactive process. High-risk scenarios involve high-conflict custody battles, credible threats of abduction, and strong ties to non-Hague nations. In these cases, demand a mirror image order to force the foreign court to legally register the U.S. custody order before travel. You can also require a massive financial travel bond, which is forfeited to fund your recovery efforts if the child isn't returned. The ultimate domestic measure is petitioning a U.S. judge to explicitly deny passport access and restrict your child from crossing borders entirely. You can also enroll in the U.S. State Department's Children's Passport Issuance Leg program. This flags your child in the system, preventing the other parent from unilaterally applying for a passport. Securing these blocks requires proving a credible threat to a judge, which means taking an aggressive, legally combative stance in court. These methods build massive international barriers to leaving, but they will permanently alter your co-parenting dynamic and drain your finances. A dangerous assumption exists that if an abduction happens, the FBI or local police will simply fly overseas and bring your child back. The International Parental Kidnapping Crime Act does make it a federal crime to wrongfully remove a child from the U.S., but the federal warrants and international notices generated by this act target the abducting parent. They do not automatically trigger physical recovery of the child. Many foreign governments completely refuse to extradite their own citizens back to the United States to face charges. A successful criminal prosecution does not guarantee reunification. Relying on the criminal justice system after the fact is an incomplete solution. Legal protection for your child must be established proactively, long before anyone reaches the airport terminal. If an amicable co-parent, implement basic parenting plan clauses for predictable travel. For the cautious planner, verify Hague compliance and tighten U.S. orders before granting consent. If a high-risk protector, aggressively demand passport blocks, travel bonds, and mirror orders. Global treaties and foreign legal policies are constantly shifting. Always consult a specialized international family law attorney to review your specific situation. Balancing your child's right to experience the world against their safety requires facing the harsh realities of international law head-on.